So I'm not going to take up any more of your time. I'm going to pass over to Professor Eleanor Flynn, who is an established professor at the School of Law and the director of the Centre for Disability Law and Policy at the University of Galway. She's published widely on the rights of persons with disabilities, and her current research priorities include legal capacity, advocacy, access to justice, and the intersectionality of disability, gender and ageing. She's also accompanied today by two colleagues who worked on this report, Dr. Suzanne Doyle-Guillot, a postdoctoral researcher at the Centre for Disability Law and Policy, and Eilish Queeve, a PhD student at the Centre. So they will be available to answer questions at the end as well. So I'm going to hand over to Eleanor now, and you have about 15 minutes, Eleanor, and I'll give you a prompt if you're going over, if that's okay.
That's great. Thank you very much, Saoirse, and thanks to IPRT for entrusting us with this really important research project. At the outset, as Saoirse mentioned, I need to acknowledge my colleagues who worked on the report with me. Just to try to keep to time today, I'll be taking the presentation on my own, but like I said, my colleagues are here to answer questions that relate to some detail of the report that they individually worked on as well. So along with Suzanne and Eilish, we also had Marini Laherty work on this report with us, and Renee Payne. So what I'm going to cover in this presentation is to give you a very brief background and introduction to this project, talking about our methods and how we approach the work. We'll go through some of the domestic and international law that we analysed in terms of how it applies to forensic services in Ireland. And then I'll try to spend most of my time talking about our analysis. So we looked at a number of different areas in relation to how people got admitted to the forensic mental health services in Ireland, what their daily life was like once admitted, how their detention was reviewed, and issues relating to discharge. And so at the end of that, I'll briefly take you through some of the key recommendations that we arrived at the end of the report, but the full report is now available on IPRT's website, and I would really encourage you to read it in detail because it's difficult for me to do justice to it in this brief presentation. So as Saoirse mentioned as well, we also were lucky to be commissioned to do that previous research that IPRT commissioned on making rights real for disabled people in prison. And I suppose informed by that and informed by the Mental Health Commission's research on access to mental health services for people in the criminal justice system, we took those as starting points for the research that we undertook into the forensic services. The main purpose of the report really was to do a scoping exercise on access to rights for people detained in secure forensic mental health facilities. So our goal is to identify what are the human rights concerns in these settings and what kinds of recommendations should we be considering to inform future advocacy and law reform. So while we spoke to people who were advocating for those in these settings and some people working in or with people in those settings, we didn't speak to anyone who was a patient in those settings specifically about their experiences. And so we think that obviously further research would be needed to really understand the depth of the experience there and think about, more long-term concrete recommendations for specific changes. So ours is really just a starting point and just an overview of the practices that we were able to glean from those key stakeholders who generously gave us their time. We conducted the research over 7 months of this year, so starting in January and finishing up in July. We started with, of course, a literature review by analysing the domestic law and including case law and legislation, and looking at how that compared to the relevant international human rights law for persons with psychosocial disabilities. So there we were really taking the UN Convention on the Rights of Persons with Disabilities as the cornerstone of our research. It informed everything from our approach to our analysis to our recommendations. And so we really feel very strongly that moving forward in this area has to be underpinned by the principles and standards that are outlined in the UN Convention, even though it does seem like a far cry from the legislation and policy that we have currently in Ireland in many different areas, including in the forensic services. Our qualitative research, we worked with some key informants, and that included 2 staff members of the National Forensic Mental Health Service, 5 advocates working in the field of disability rights, working with specific groups, for example, including autistic people, people with intellectual disabilities, people with psychosocial disabilities, and so on. We also interviewed a lawyer working in the area of forensic mental health and criminal justice, and 2 organisations that were working within the forensic mental health system as well. So from the domestic and international law side, like I said, the convention was the cornerstone of our research. And while Ireland has ratified it since 2018, we have not yet ratified the optional protocol, which would allow individuals to take cases to Geneva where they believe that Ireland has violated their human rights under the convention. The convention really represents a paradigm shift in how we think about the rights of disabled people, particularly in issues related to mental health, because the convention, of course, calls for abolition of all forced treatment and coercive practices within mental health settings, and a shift to basing treatment, all health treatment, including mental health treatment, on the free and informed consent of the individual. So this is based on that obligation to remove discrimination based on disability and ensuring quality of disabled people in law and policy. Committee on the Rights of Persons with Disabilities that monitors the convention has set out a number of standards in further detail in its general comments, including general comment 1 on Article 12 on legal capacity. And the committee has also, for countries that have ratified the optional protocol, heard a number of cases involving people detained in forensic settings and considered the human rights violations that they've experienced. A very famous case is that of Marlon Noble, an Aboriginal man in Australia who was detained following the finding that he was unfit to stand trial for 10 years in various settings and then for 13 years in the community under very restrictive conditions, which the committee found amounted to a deprivation of his liberty in the community. So, how do those standards apply when we look at forensic mental health detention in Ireland? Well, we had to look at the different laws that govern how people get admitted and reviewed and discharged from forensic services. So, of course, there's the Criminal Law Insanity Act 2006, where people are found not guilty by reason of insanity and may be admitted to the Central Mental Hospital. And that is where the Central Mental Hospital is the only secure forensic mental health facility that's recognised as a designated centre under that Act. We know that about 80 to 90 people are detained in the CMH at any one time. And of course, that the National Forensic Mental Health Service based in the CMH is transferring to Portrane campus in the near future. So again, many of the advocates and informants that we spoke to had outlined some issues that they felt might be resolved following the move, but also other things that would still need to be worked on. In terms of our analysis then, and I'll try to give this a little bit more time because I rushed through the first few parts in order to spend a bit more time here. We started by looking at the admissions process, and we considered all of the different ways in which people might end up in the forensic mental health services. So first, as I mentioned, of course, there is the finding that somebody would be not fit to stand trial and therefore maybe admitted to the CMH on that basis. Of course, people are sent to the CMH because of findings that they're not guilty by reason of insanity also. But in addition to those maybe obvious routes, we know that people can be transferred to the CMH from the prison environment. And also that people may be admitted to the CMH under the Mental Health Act, where they have first been admitted to an approved centre under the Mental Health Act as an involuntary patient. But finally, there's also the possibility that when someone is made a ward of court, they can be admitted to the CMH on that basis. They can be admitted to forensic mental health services once they're following their process to make them a ward of court. So just looking at those admission routes in terms of the human rights obligations that Ireland has signed up to, we would be concerned that there are a number of conflicts there with the ways in which people get admitted to the forensic services and Ireland's obligations to uphold the rights to legal capacity, to access to justice, the right to liberty, and the right to health as set out in the UN Convention. So the fact that people are admitted in these ways is typically based on a finding of past or present legal incapacity. And in that way, it is a form of substitute decision-making, which the UN Committee has called for the abolition of, and its replacement with supported decision-making. And even though there is some work ongoing on that front with the development of the Assisted Decision-Making Capacity Act and the amendment to that act, which is currently before the Seanad, this is not sufficient to really realise that right in full, especially for people currently detained in the forensic mental health services. Access to justice is another critical issue for people during the admission process and during the entirety of their stay in the forensic mental health services. So particularly where there are involuntary transfers, for example, from prison to the Central Mental Hospital, the extent to which someone has a legal remedy to challenge that placement is very limited. So access to justice concerns really arise there. Obviously, there's an issue with the right to liberty, particularly if we consider that detention on the basis of the person's psychosocial disability or mental health diagnosis can often outlast any detention that would have occurred if the person were simply in a prison setting. So that length of detention is an issue as well in terms of the right to liberty. And finally, then there's the issue of forced and coercive psychiatric treatment, because of course, according to the UN Convention, the right to health outlined in Article 25 requires that no forced treatment is undertaken, and that instead people can only receive treatment where they have freely given their informed consent to it. Now, that is a challenge for all countries around the world, and one that we are not close to solving, but it is important for us to be clear. This is the obligation to which the UN Committee will hold Ireland when it is before it in Geneva during its dialogue on its first state report, which has now been submitted. In terms of daily life in the Central Mental Hospital, there are a number of issues that people outlined during our interviews. So we considered the access to healthcare that people received, both in terms of the physical healthcare available and the mental health care, with again, informed consent being a central concern around how people actually accessed healthcare and the type of healthcare that they could receive. We were concerned about the practice of nighttime confinement, which was reported as being widespread, with all but one unit having, I suppose, a nighttime confinement that occurred just before 9 p.m, sometimes earlier, and in the other unit was open then until 11 p.m. But for that whole entire period then, people were confined and didn't have open access to, for example, toilet facilities outside their cell. So this is an issue in terms of how the experience of daily life is for people in forensic mental health services. The forensic mental health services also have very high levels of the use of seclusion and restraint, as acknowledged by the Mental Health Commission, and participants in our research also highlighted this and highlighted that perhaps there weren't enough efforts to use alternatives before these types of seclusion and restraint were used, and that there needed to be greater resourcing and opportunities to try alternatives in that context. The ability for people detained in the services to access and maintain their connections to community through family visits and opportunities for leave was also extremely limited. So that was a concern that was identified to us. And the role of advocacy, the access that advocates might have to people in the setting, and the independence with which advocates could operate in that setting was also a key concern. We acknowledge in our research that we didn't have sufficient space to really analyse in detail the gender implications of people's experiences in forensic mental health services in Ireland, but we do think that this is an area for future research, as well as identifying more open and transparent means of complaints mechanisms where things could be stored holistically in processes that were clear and accessible to all. In terms of our review then of detention and discharge, we identified a number of different issues, which again, I'll touch on briefly now. First of all, thinking about the role of the Mental Health Criminal Law Review Board, we were concerned about the absence of lay members from that board, and of course the absence also of people with lived experience of mental health services, and including forensic mental health services in that process. And again, a very small pool of legal representatives under the Criminal Law Legal Aid Scheme for mental health that would be available to act for people in these settings. Limitations on the role of the advocate in the hearings was also acknowledged by many as a frustrating aspect of the review process, as well as the lack of parity with the Mental Health Act tribunal powers. So no requirement for an independent psychiatric opinion, and default 6 monthly reviews versus the initial review after 21 days. So there's a big difference in the length of time before the review needs to occur when you compare with the process under the Mental Health Act tribunal. Again, the level of participation that individuals actually had in the review process was something that participants outlined to us they had concerns about, and particularly the need for more accessible information about the review process and how it operated. There were also some discussions about how the assessments of risk were undertaken in that process and how they could be framed by concerns about clinical liability. We have outlined in the report a number of concerns about the process of conditional discharge. So in particular, we're concerned about the imposition of highly restrictive and coercive conditions as part of that process. And again, the apparent practice of having to have a conditional discharge before the person can be unconditionally discharged, even though there, in theory, and our reading and analysis of the legislation, there is no barrier to direct unconditional discharge. We're just not sure that this is actually happening, even though in theory it could happen. So the clinical director under this process of conditional discharge has actually got the sole power to form the belief about breach of conditions. And that, of course, then is what dictates whether the person is returned to the CMH or not. And finally, then the availability of conditional discharge was often limited by resource constraints in the community. So people weren't getting the opportunity for conditional discharge because there wasn't the support there for them to have that option. And again, even though people would have completed all of the steps required of them and gone through all of the 7 pillars of care in the forensic services, they were still not accessing this option. Final issues around discharge include challenges, including sustained support once the person had been discharged, and the impact of stigma on the person after discharge in terms of reintegration into the community. We were also concerned about the requirement that there should be a transfer of the prisoner back to the prison setting as a prerequisite for parole and early release, that the person could not just access those options directly from CMH. And also involuntary admission or extension of detention in the CMH was possible at the end of a prison sentence, which again raises some of those issues I mentioned previously about the right to liberty and access to justice. So ultimately, our key recommendations and advocacy priorities would be, of course, our goal has to be, as the convention requires, the abolition of the coercive system that allows for forced treatment in all aspects of the mental health services, including the forensic mental health services. This is consistent with Ireland's obligations under the UN Convention, even though it is extremely challenging, and we acknowledge that. In terms of more immediate steps that could be taken for those who are impacted right now, and we are very conscious that there are people living in the forensic services right now that need support, and we need to think about how we could respond better. So our suggestions here are to lessen the harms that people are experiencing in the short to medium term. We could start to adequately resource and offer mental health treatment outside the CMH, reduce the reliance on it as a setting. And again, the key will be to base that treatment on the free and informed consent of the person, as the UN Convention requires. And if that's not possible, if the person is in prison, for example, and the type of support that they're looking for in terms of managing emotional distress or different experiences that they're having is not possible in the prison environment, then just like we would do for anyone with a physical healthcare condition, we should offer the person the option of accessing that service outside the prison environment for the time that they need it. Access to independent advocacy is critical for people in the forensic mental health services, and there are a number of different organisations that could play a role here. And the role of people with lived experience and peer support was really highlighted to us in this process. Greater access to all of that would really improve conditions for people currently in forensic services. Visiting is also critical, and access to leave needs to be expanded. We need to explore alternatives to seclusion and restraint in a more meaningful and comprehensive way. And ultimately, we would suggest beginning that process of abolishing the system of conditional discharge and extending the practice of extending detention beyond the length of somebody's prison sentence. So I'm sure there'll be lots of questions about these recommendations, and I've only outlined them very briefly in this presentation. So I'm happy to take questions, as are the rest of my colleagues who are with me today. And again, I would encourage you to read the full detail of the report where I explain some of these issues in a lot more detail. Thank you very much.
Thanks so much, Eleanor. We really appreciate that. And as Eleanor said, the report is on our website now, and it is really comprehensive for a scoping study. I think we had to kind of rein the researchers back. They had gathered so much information, and it's really the first time that we've looked at this issue. So I think it is something well worth reading. So now I'm going to ask our panelists to switch on their cameras, and I'm going to introduce them. We have Michael Lynn, who is senior counsel. He's established senior counsel with extensive experience working on cases relating to both criminal and mental health law and the intersection of both. Michael is further a committee member of the Irish Criminal Bar Association and a member of the Bar of England and Wales and Bar of Northern Ireland. I know Michael may have to run off to court, so we'll probably come to him first for some of the questions. And we'll try and keep our answers short and succinct so we get as full a range of discussion as possible. We also have Shalom Binchy, who's a solicitor with over 25 years experience representing clients in criminal and mental health law. She's a former chair of the Society's Criminal Law Committee and a current member of the Policing Authority. We then have Ber Grogan, who's Policy and Research Manager at Mental Health Reform, Ireland's leading national coalition on mental health. Prior to her work with mental health reform, Ber worked in Dáil Éireann as a parliamentary assistant and also in the areas of homelessness, community development and reintegration supports for people leaving prison. last but not least, we have Molly Joyce, who is our IPRT's own Legal and Public Affairs Manager and Deputy Director. Her background is in law, and she previously worked as a barrister in England, specialising in matters relating to policing and public law. So I have a number of questions that I'm going to put to the panel first, just in response to the report, and they did have sight of it before, so we're not just springing it on them as well. And then I'll invite the researchers to join for the Q&A at the end. And we are already starting to get a number of questions in, so please do put your questions in. We would appreciate them, and we'll try to get to as many as possible. So I'm going to go to Michael first, just in case you do have to run off, Michael. But from your own perspective and work, what do you consider the primary human rights issue arising in the forensic mental health system is as it currently exists in Ireland?
Well, Saoirse, firstly, thanks very much for inviting me to participate. It's a real privilege. And I have to say, I mean, you sent me over the draft report last night, and just for everybody who's listening, this is really challenging reading because, I mean, Eleanor has already said this. The Convention on the Rights of Persons with Disabilities really is challenging the status quo in a most fundamental way. And the idea that we should be working towards getting rid of a coercive forensic system is very, very challenging. And I might later say a few words about the Constitution, but the specific question you've asked me, I think probably, I mean, that is really, I suppose, the primary human rights concern. And in particular, and the report highlights this, forced treatment and the coercive nature of the CMH. Now, the traditional answer is going to be that for many people, this kind of coercive restricted setting is required for their own safety and for the safety of others. Now, quite how we're going to overcome that common sense approach, I don't know, and that's really the challenge. I mean, I remember a case that happened to represent an applicant back in 2009, and he was a voluntary patient in an approved centre in Navan. And he was having his treatment, and he voluntarily was admitted and was in a long program of treatment, but it wasn't working out, and it was felt that he needed to go to the CMH. And what happened was they discharged that man in the accident and emergency unit, and then they admitted him to the same approved centre under the Mental Health Act so that they could then transfer him to the CMH. And we brought a case with a very simple proposition. Is it possible to be a voluntary patient in the CMH? As a matter of one's own dignity, can you not volunteer for a specific program of treatment? And we lost the case on the basis that the CMH's director, Professor Kennedy, was resolute that it was a coercive system and you couldn't voluntarily receive treatment in it. So sorry, that's just a short answer, and I don't want to take everybody else's time. This is a really challenging report, and really exciting to think about where it might lead to. Saoirse.
Thanks, Michael, and thanks for coming back on that. I'll go to Shalom next. Same question, just from your own perspective and your own work. What do you think is the key human rights challenge after seeing this analysis and findings in the report?
Thanks, Saoirse, and just thanks for inviting me to be here today. So I'm coming to this from perspective of somebody who did criminal defence work for many years and now practices predominantly in the area of mental health law. So the report is really welcome. It really shines a light on the forensic detention services here, the CMH, a light that we don't really often see. And I like the way it looks at the overview and then right down to the minutiae of daily life for the people who are there. And I think that's very important. To answer the question, for me, I think the really important human rights factor is that we have a lack of services that are leading to people ending up in prison and they're then into the CMH, and people who maybe shouldn't be there, people who have been failed by our health system in the first instance. And then what we see in this report really shows this in a very clear way, is that people can't get out of the CMH because equally there's a lack of facilities to allow them some sort of step down, some middle ground between being detained in a really very restrictive setting and a very difficult setting where there is this forced treatment, coercive restraint in some instances, and there is no middle ground. So therefore, they're basically stuck there, sometimes indefinitely. And I've had personal experience in representing people who fall into that category, and it's extremely difficult as an advocate and extremely difficult for those patients. So that would be my primary issue.
Thanks, Shalom. And I'll come to Bear next, and then I'll go to Molly to wrap up that question before we move on.
Thanks, Saoirse. First of all, I can't believe you told everyone we got the report in advance. I thought we were going to have an opportunity to wow everyone with our on-the-cuff.
Sorry.
No, but as the others have said, it's a really, really brilliant report. And I suppose those of us familiar and who've worked with Eleanor on other pieces around assisted decision-making maybe aren't as surprised reading the report, because Eleanor and the team in Galway are always so true to the UN Convention on the Rights of Persons with Disabilities. So I think for me, there's a couple of things. Obviously, the increased use of seclusion and restraint is a worry, but I think that a point that links in with what Shalom was saying is the deprivation of liberty. And we know that Articles 12 and 14 of the UN CRPD that link directly with capacity and liberty, that the Irish state has declarations on both of those articles. So, it's kind of like that thing of we're either, following our obligations under the UN CRPD and we're not. And in the case of people with psychosocial disabilities, on two very, very important articles of the UN CRPD, the state have said, well, not for those people, So for me, that's a big concern for our members in mental health reform.
Thanks, Bear. And I think, a lot of what you're all saying tallies with some of the discussions that myself and Molly would have had after reading the report. But Molly, do you want to kind of come in there on anything that hasn't been covered, or to give IPRT's perspective on and reaction to the report?
Absolutely. Well, I think, all the comments that have been made are, again, as Saoirse said, things that we kind of have discussed ourselves. It is a very challenging report, and I think it is challenging for those of us like myself who don't have a background in kind of mental health or UNCIPD or disability and rights kind of that kind of area. So I think it is challenging, but I think it's really timely. And I suppose from IPRT's perspective, we have always approached it that we are obviously looking at prisons primarily, and we know, prisons have been described as being left to pick up all the pieces of the failings, as Shalom mentioned, in the healthcare system, really, in mental health care. And what we know is that prisons and prison staff are not resourced or equipped to actually provide the support that is often needed for people. And so really, as Saoirse mentioned, the whole point of going for this report was to try and kind of actually understand about the rights aspect, because in IPRT, we often would kind of be looking solely at the prisons, but not so much at what happens when someone is then transferred. We talk a lot about waiting lists, but we're not looking at that more substantive piece of what happens on the next step. So this is what this report was about. And in terms of, all of the things that have been mentioned, but I think for me, what really stood out as the kind of key human rights things coming out of this specific report is the point that's been made by others, the lengthy periods of detention, the fact that people can kind of end up in this kind of gap where there's no clear pathway onwards, and that people, it seems, can actually potentially end up in the CMH for longer than they would have ended up in prison for a sentence. And that's really concerning to me. The other thing is around seclusion and restraint, because that would have been relatively new information for IPRT. As I say, it's not something we've kind of looked at very specifically, that aspect, what happens in the CMH. And I think there's some good quotes within the report in terms of, some of the people who were interviewed about, describing what that actually means, because we use those terms, seclusion, restraint, and you can kind of nearly forget that actually involves someone being held down and forcibly injected, and that it is actually pretty, not to say that as I said, I don't have expertise, I don't know kind of the ins and outs of the challenges working in that environment, but it's just to say that is something I think is kind of new to us, and it's definitely a matter of concern.
Great, thanks, Molly. And I think we probably touched on some of what I'm going to ask you next. Like about what the biggest challenge is to getting a CRPD compliant system in place. It is, and I think we've tried to capture it in the report. Certainly the researchers are very cognizant of it. It's a very high standard. The human rights standard is a very high standard, but we should always be working towards that and not regressing. So I'll go to you first, Ber. What do you think is the biggest challenge? And obviously you'll have seen maybe things in your work that we might not have.
Yeah, so I suppose, you know, in mental health reform, we have 80 members working across the sphere, from homelessness, addiction, working with vulnerable young people, traveller mental health. So we get quite a broad range of views linking to mental health and the reform that's needed. And I suppose one of the things that I think about the word challenging, and when we're talking about, you know, this report and these findings kind of challenging us, to me, I see it as a really exciting opportunity. And I think we can easily get bogged down in the challenges or the barriers to change. And I think one of the biggest changes is the culture shift that's required. And I think one of the terms used relating to the UNCRPD is a paradigm shift. And we have to start somewhere with that, you know. And I think we've had between different reports and work that's been done, there's evidence there that we can take some small steps. You know, it's not going to be changed overnight. And I think the report's recommendations about the inclusion of lay people on review boards, listening to people with lived experiences. We know under the UNCRPD that, you know, the state has an obligation to consult with people with lived experience. So there are things that we can just start processing and implementing into all of our daily work. And by listening to people who have lived experience and who have maybe been through the forensic mental health systems, how they felt when maybe seclusion and restraint was used, how traumatic it might have been for them, you know, looking at things from a recovery oriented and trauma informed point of view as well. We can all learn from that, and it makes for a better environment for the people accessing the care, but also for a better environment for the people delivering the care and the services. You know, we know that research will show that you have less sick days, you know, all of that kind of stuff, that there's a higher satisfaction with work because you're working, focusing on everyone's human rights rather than, you know, maybe more punitive ways of not having resources and having to rely on coercive practices. So yeah, so instead of challenges, I would like to say that the exciting opportunities that we have, and the UNCRPD, you know, these changes are happening globally. You know, we're not the only country kind of looking at this, and there's already some best practice in other places that we could be looking at. And I see some of the questions there are already mentioning psychosocial reports and things like that, but I might be straying a bit ahead. But yeah, so exciting opportunities.
That's great, and thanks for reframing it like that, Ber, as well, because it is. And I think, you know, one of the things that we really thought about when we read it was that challenging aspect, but it is an opportunity because we haven't looked at this in any real detail before. And, you know, part of the scoping exercise is to look at what can be done and how we can work together, and we'll come to that in a moment as well. Michael, I'm going to ask you, you know, what you see as the biggest challenge, or should I say opportunity, to change in this regard?
Well, Saoirse, can I say maybe two sort of things? Firstly, I mean, we've been very slow in bringing in legislation to, in part, give effect to the Convention on the Rights of Persons with Disabilities, and that's a problem. And then secondly, I think we're going to need to really change the legal mindset and the judicial mindset and practitioners' mindsets completely. And I wanted to say a word on the Constitution on that in a moment. But I mean, unfortunately, as Eleanor said, I mean, we didn't ratify the convention until 2018. It had been ratified by the European Union way back. In fact, it's the only international human rights treaty that the European Union as an institution has signed up to. So in fact, it would have been enforceable here in a case that involved EU law, but that kind of a case would probably only come around very rarely in the criminal justice system, if at all. So we've been very slow to implement it, and the Assisted Decision Making Act still isn't properly in. It's not. I mean, it's supposed to be in. There's a case in the High Court challenging the wardship system, And that case has been adjourned because we were told that the assisted decision-making system would be in by June or July, and it's still not in. And there's a very, very interesting part of Eleanor, the IPRT's report, the scoping report, about the use of wardship to detain people in the CMH, a system that we have to and will end. And that's what the Assisted Decision Making Act will do, and that's what we're obliged to do, but yet it's still being used. So there's a problem in that we're very slow as a matter of government policy to embrace the CPRD. Now, how are we going to try and use the CPRD? And this is where I think, I mean, all of us, academics, practitioners, the activists, this is where we really need to think how the CPRD, just for people who aren't familiar with international treaties, it's not part of Irish law, even though we've ratified it. It has to be given effect in domestic law. So we can't really use it unless it's specifically parts of it are enacted. But I think we can use it as a guide to how we interpret our own constitution. Now, it's still such a radical instrument, the CPRD, that it's going to be very difficult to use in that way. But there was a case, MX against the HSE, it's 2012, volume 3, Irish Reports, page 254, in which the High Court said that the CPRD was something that could inform how we interpret and apply the Constitution. And we know that it's used by the Strasbourg Court in interpreting the European Convention on Human Rights, and the European Convention on Human Rights can inform our own Constitution. So it can be used, but it's so radical that I think we really need to collectively think, how can we use this instrument, the CPRD, to really develop our own constitution? And our constitution is very much the primary instrument. The Supreme Court have said that, by the way, in 3 or 4 very recent cases, not the ECHR, the constitution. Now, one thing I wondered about is we don't have the right to dignity as such in our constitution, but in the preamble there's reference to dignity, and the Supreme Court has said that it is a constitutional value. And I wonder if in the area of mental health, detention, the dignity of the person is something that we should be trying to develop as perhaps underdeveloped at the moment in the jurisprudence. And it actually ties right in with what Bear said, which is that we should be listening to people who have had a lived experience. That's the note I've made. Because I think people with real experiences can help us as academics and practitioners and policymakers to develop this concept of individual dignity. So there are some very, very preliminary thoughts from me, Saoirse, because the report, honestly, there's so much in it. But I'll leave it at that. Thank you.
Thanks, Michael. And I think it's really interesting to hear, you know, I think ratification of international treaties is an issue right across the board, and certainly one IPRT grapples with all the time in trying to convince the state to ratify before legislation, because we could be waiting a very long time for legislation. But I think you've given some really pragmatic ideas, hopefully, to some of the other members of the legal community, including judiciary, that are here, just around how CRPD can inform some of the decision making around this. I think that's really useful, and maybe something we'll come back to later. Molly, I'm going to come to you next, and then I'll go to Shalom on this question before we move on.
Yeah, I'll keep my remarks very brief, because I think there, Michael, I've really addressed quite a lot of the key kind of challenges coming up. I suppose it's just to echo that. I think for me, what kind of seems one of the most obvious challenges is this kind of paradigm shift, this fundamental shift in how we think about this. And I think as well, what I kind of came away from the report, you know, finding was that the kind of some of the recommendations and the overall kind of goal will actually involve also not just reframing our forensic mental health system, but in some ways our entire kind of criminal justice system and how we think about what we're doing with criminal justice. Because for a lot of those recommendations, I suppose, to work, we would need a more effective criminal justice system that maybe looks at a, you know, has a more restorative approach, isn't kind of based on this very traditional legal approach that we've taken, you know, to date. And so I think that is quite a big thing. And I like that Bev kind of phrased it not as a challenge, but as an opportunity, because I think that is kind of, it's a really massive thing to think about how we entirely kind of reframe our ways of dealing with people that we deem, you know, problematic, or whose behavior we can't handle as a society. And I think, you know, looking historically, we've seen so many different examples of people who may well have been well-meaning, but we've seen the kind of human rights abuses that have been conducted in the past, and it appears potentially are still ongoing. And so I think, yeah, there's kind of a real paradigm shifting thing. And I suppose then just to mention resourcing, which is kind of a, you know, it's not just resourcing in terms of just physical money, but actually a redistribution of resources and how we think about where we're putting our resources, and are we putting them into institutions, are we putting them into community-based support?
Thanks, Molly. And I would say an increase and redistribution of resources, perhaps, because we know that that mental health right across the board is chronically underfunded. So thanks for that. Shalom, is there anything you'd like to add there, or anything we haven't covered, or would you like to reiterate any of the points made?
I think it'll be more reiteration. I mean, the two big challenges that I see are changing the mindset. So I think we still view the CMH in terms of being a punitive place, and although it's a hospital, I think that there is a mindset of punitive treatment and also fear. And we saw that in the report where one of the clinicians said, you know, what happens if somebody's discharged and something happens? Are we going to be liable? So there's the fear feeds into the mindset there. And I have to say, I do find the CRPD model, it is quite a radical model. And when I was reading the report, I was thinking, well, what do you do if you have no CMH? What is the alternative? So I think to try and address those issues of fear, we really do need to know what the alternative looks like, because it's very hard to talk about getting rid of one system until you know that you have a really good, solid alternative. And in this area of mental health, we have an example of where that can go wrong, because a few of us have mentioned already that community-based mental health treatment in Ireland is really lacking. And in this country, we closed down lots of our community hospitals, and you know, what we saw as a Victorian model, and we closed those hospitals down, county homes, places like that. And there was lots of good reasons that they were no longer a suitable model. However, what we didn't do was create an alternative, and that has left us with this massive gap where we now have people who are untreated, who have mental health issues in our community, and who are ending up in the criminal justice system. So I think it's really important that while we're talking about the problems in the CMH, you can't move on to the next step until you know what that looks like, and that it's a good alternative, and that it's going to work. And then Molly mentioned resources, and I see that as a massive challenge, because, you know, every year we hear that there's so much money ring-fenced for mental health, but we haven't been seeing the changes in community-based treatment that we need. So resources is just a massive issue in terms of bringing in the CRPD model.
Great, thanks, Shalom. And I suppose the final question before we bring the researchers back in, so I'll ask you all to keep it as brief as possible, because we do want to have that conversation with the researchers as well, is just how do you think law and civil society can work together to progress the changes needed? So is that through litigation? Is it through legislative reform, advocacy, campaigning, changing attitudes and hearts and mind, including our own, I would say sometimes? Or is it a combination of all of them? Molly, I'll go to you first on this one.
I'll be very brief. So I think it's to me, it's very much about changing minds and attitudes, which I think has come across from a few of us here today. And I think, you know, Michael said it and Shalom, but, you know, as NGO workers, but also, you know, as members of the legal profession or working in that environment, it's about being open to challenging our own assumptions and our own kind of default views about what's right or what's not right. But also I think the kind of collaboration advocacy point of view, you know, I think it's really important to be speaking to each other. And, you know, I do think there is probably a lot of disagreement, perhaps, you know, across the board about what is the right approach. But I think as long as people can kind of try and have a conversation about that and actually be willing to kind of challenge their own assumptions, but also be willing to challenge others who, you know, if there is a strong point of disagreement with UNCRPD and this kind of, you know, ideal framework as a potential guide, I think that is probably one of the ideal, ways to progress. And I think, Michael and Shalom and they will all have really interesting perspectives from the legal side and from the kind of more NGO advocacy side in the mental health area.
Great, thanks, Molly. So I'll go to Shalom next then, maybe for the legal perspective.
Well, obviously, I think, there's a lot more scope for advocacy groups and lawyers to really talk to each other. I mean, we tend to operate sort of in our own individual spheres, and there isn't enough crossover in my view. So I think, that can be done. Litigation is an important part, I think, of bringing in change. And, we can see Michael referred to the fact that we haven't brought in ratified the optional protocol on this. So while the state has obligations to report on the CRPD, individuals can't litigate. And I think if they could, we'd have seen a lot more reform quicker. So litigation is a very important part of reform, and I think there always has to be room for that. It's not the ideal, because it's stressful, long, complicated. It's certainly not the ideal. So, I mean, legislative reform, resourcing they should be the primary movers, but there should always be room and an allowance made for litigation for particularly difficult cases. But I do think there is scope for all of us, people working in the mental health system, patients, advocacy groups, NGOs, to work together in a more concrete way than we do at present.
Great, thanks, Shalom. Anything to add, Michael, to that? And then I'll come to Bear.
Well, I agree with everything that Shalom and Molly have said. I think changing hearts and minds, which is what Molly said, is probably the key to it. I mean, I would say, unfortunately, I think achieving change by litigation is going the change of the magnitude that the CPRD is suggesting is going to be extremely difficult. I mean, it's really quite recently, Saoirse, our courts, and this isn't a criticism of it, but I mean, our case law is that we adopt a paternalistic approach. I mean, our courts have expressly said that, 15 years ago or so, and perhaps there's been a slight move away from it. But I think very difficult to achieve it by litigation. But that's not to say that bringing litigation would be unmerited. I'm not suggesting that. But I think it's really changing attitudes that's probably the key to this.
Great, thanks, Michael. And Bear?
Yeah, I suppose I obviously agree with everything that everyone is saying, and I'll go a step further to say, like, that collaboration could be more structured, and that kind of a more open flow of conversation and knowledge sharing. So, for example, there's loads of public consultations through the Oireachtas or through the UN processes that we could, and I think we are getting better at it, and I think a lot of us do it anyway. That we can, but it would be great to get people in the legal profession as well. NGOs, if they're very small, they don't necessarily have the kind of the policy or the research staff or time or capacity to do all of these public consultations. But then if we're not taking part in the consultations, then the government will say, well, sure, we gave you an opportunity and we didn't hear from you. So I think, yeah, more collaboration on that way will strengthen the advocacy and the legislative reform and the what you said about changing hearts and minds as well.
And I think that's a really good point. And often those consultations come with a very tight turnaround time. So, sometimes you have to question how meaningful they are. But I think all of us in all of our NGOs, we try and really strive to input as much as we can, but it just isn't always possible. But in saying that, we really welcome the consultations. So I'm going to ask Eleanor, Suzanne and Eilish to turn on their cameras now. And if they want to, before we get into some of the questions that are coming in the Q&A for you, I just wanted to ask, do any of you have anything to add to any of the points that have already been made, or, want to supplement those?
Maybe just to acknowledge, I suppose, everyone, we're talking about how hard it is to do this work, but we do have roadmaps and we do have examples of good practices from many other jurisdictions. Again, nowhere has a perfect system, and also it wouldn't be appropriate to just try and copy and paste things into an Irish context. But there are lots of different examples that we can draw on of, particularly when we talk about alternatives to the coercive system. So Shalom and others raised that point of, okay, well, we can't abolish something until we know what's going to replace it. So we need to understand that. But we have so many, and we didn't have time to write about all of these in the report, and some of them we've only mentioned briefly. But there's a growing knowledge about alternatives, whether, you know, that really, and I'm not talking about alternatives in the general sense, I'm talking about targeted practices that work specifically for people who are particularly marginalized, particularly at risk, you know, have lots of intersectional experiences related to poverty, homelessness, emotional distress, you know, that really look at those excluded groups and find ways, particularly led by peer support, intentional peer support, things like the personal ombud system in Sweden, things like the open dialogue practices in Finland. There are lots of different ways that have had huge success rates in responding to people who would previously have absolutely been institutionalized and subject to very high rates of forced treatment. So, you know, there is hope. We should focus on those practices, and there is examples of some of those practices being trialed in Ireland, again with some great success. But these are not the things that receive the majority of the resourcing and the majority of the support. So as long as we're still funneling the majority of our resourcing into the coercive options, it's going to be very difficult to actually dismantle them. So the two things really go hand in hand, as everyone has been saying. So that's just I mean, it touches on some of the questions maybe we have in the chat as well, but that's just one thing I felt we should add to the conversation up front.
Great. And what I might do is go to some of those questions now, and then if any of the other researchers or any of the other members of the panel want to come in on a specific point, just maybe raise your hand and I'll come to you. So we do have a question